Today is 1st August 2020. It is on this day, 100 years ago, one of the greatest national leaders of the struggle for Indian independence, Lokmanya, Bal Gangadhar Tilak, passed to the other shore. Undoubtedly, one of the brightest sons of India who laid the foundation of Swaraj, self rule. An humble attempt to give a tribute to this prince of the people by highlighting the trial he faced in the year 1908 for sedition. Lokmanya Tilak argued his own case for 21 hours and 10 minutes, spread over 5 days in the Bombay High Court. It is necessary to give a factual background of the case, as the trial was based on the two articles in Marathi written by Tilak in Kesari newspaper after the killing by hand bomb of two women in Muzaffarpur in Bengal. Lord Curzon partitioned Bengal in the year 1905. The Bengalis persistently agitated against the partition of Bengal in a constitutional manner, but they did not get any redress. They resolved to peaceful agitations like Swadeshi, boycott of foreign goods, self reliance, creating natural awareness, etc., etc., but to no avail. On 30th April 1908, two young Bengalis, Prafulla Chaki and Khudiram Bose, threw a bomb on a carriage at Muzaffarpur to kill the Chief Presidency Magistrate Douglas Kingsford of Calcutta, but erroneously killed two women traveling in it. While Chaki committed suicide, Khudiram Bose was hanged. Tilak wrote an article on 12th May 1908 in his Marathi newspaper Kesari titled Desha Se Durdaiva, meaning the country's misfortune, and another article on 9th June 1908 titled He Upay Tikau Nahit, meaning these remedies are not lasting. The subject matter was in reference to the happenings in Muzaffarpur in Bengal. At that point of time, Tilak was undoubtedly the most popular national leader of Indian National Congress in the whole country, spearheading the self-rule or Swaraj movement. On 23rd June 1908, Tilak was arrested in Bombay, denied bail by Justice Dawar of the Bombay High Court. After the arrest of Lokmanya Tilak, his house at Pune was raided and searched. After 2.5 hours of extensive search and scrutiny of each and every paper in his press and house, Inspector Sullivan found in one drawer, under a heap of papers, a small postcard with the names of two books on explosives. As the trial was related to bombs and explosives, the inspector in charge considered these notings on the postcard as a conclusive piece of evidence and wound up the search. The trial commenced on Monday, the 13th July 1908 in Bombay High Court. The charges framed were under Section 124A for sedition and 153A for inciting enmity between two classes or religious groups. At that time, jury system was prevalent in the courts. The judge to interpret the law and pronounce judgment, and jury to give verdict on finding of facts. The jury consisted of respectable members from the city. Tilak insisted that the trial is based on articles written in Marathi. The jury should not have Europeans or Britishers, and the jury must consist of members who know and understand Marathi language. This was within the right of the accused, and Tilak rightfully pleaded for the same. However, the same was denied, and following 9 persons were named as juries. 7 Englishmen, namely Mr. Wood, Mr. Gregg, Mr. Hilliard, Mr. Dover, Mr. Hudson, Mr. Hempson, and Mr. Anderson Martin, and 2 Parsi gentlemen, namely Mr. Shapurji and Mr. Palanji. It is pertinent to note that the trial was based on articles written by Lokmanya Tilak in Marathi language in a Marathi newspaper, and none of the juries could understand Marathi. They relied on English translation done by the official translator. At the commencement of the trial, Lokmanya Tilak objected to the applicability of Section 153 of the Indian Penal Code. Tilak's arguments commenced on 4th day, that is 16 July 1908. As mentioned earlier, it lasted for 21 hours and 10 minutes, spread over 5 days. Possibly a record of sorts for a non-practicing lawyer arguing and defending his own case. A brief outline or gist of his line of arguments is being summarily placed before you, as otherwise it will run into several pages. Tilak began his argument by saying that both the articles, which is the subject matter of the trial, are in Marathi language. What you have before you, he addressed to the jury, is translation and not the original article written by me. None of you, the honorable members of the jury, understand Marathi language. In Marathi, each word has its own phonetics and puns, that is, double meaning. Intention and motive is considered essential for establishing the charge of sedition. Possibility of sedition and whether act of sedition was actually committed must be distinguished. No evidence as to whether my articles provoked any anger in the minds of the people against the government is produced. The burden of proof is on the government to establish that the offense of sedition was committed. Section 124A talks of government. It does not apply to government officials. Government established by law does not mean government officials. Tilak asked, which statements in the articles attract Section 124A or 153A is not mentioned. Entire article is covered, becomes a vague statement and thus inadmissible. My articles were in response to the articles published in certain English newspapers. For example, Pioneer, after the bomb incident in Muzaffarpur, wrote, "Cult of terrorism begins." I responded, try to analyze the reasons also as to why such extreme steps are taken. Articles are written in 1908, but the translation is done on the basis of dictionary published some 15 years ago. What impression jury may have by reading English translation and what impression a Marathi knowing reader will have may not be the same. You may summon some of the readers of Kesari as witnesses in the court and see for yourself. Tilak said, articles are about the unrest and dissatisfaction in the minds of Bengalis. No one reads Kesari in Bengal. This is an important aspect for consideration of honorable members of the jury. English newspapers were advocating strong repressive measures to be undertaken by government. My articles were in reply to these articles. I exhorted for analyzing the cause of unrest and dissatisfaction in Bengal. What is wrong? Even Lord Morley says we must establish peace and harmony in the country and work for political progress. Lord Morley at that time was a state secretary in England for India. Tilak further argued, English newspapers advised the government for repressive measures and imposition of martial law. I say punish the wrongdoers, establish peace, but give political rights to the natives. What is wrong? Lord Macaulay had called Bengalis docile. When an otherwise peace-loving, docile citizenry turns to violent means, government must analyze the reasons and not go for repressive measures, argued Tilak. What wrong did I say? If I say Britishers have come here to rule and not to do charity, is it wrong or incorrect? My articles were intended to give a wake-up call to the government to take corrective measures and not resort to repressive measures, as that would not establish peace and harmony in the country. Even Mr. Gokhale, Mr. Rash Bihari Ghosh and Mr. Firod Shah Mehta have expressed the same opinion. Only my language is stronger and I have not used any foul language. One Anglo-Indian newspaper has said, political activists in this country must be thrashed by a broomstick. Sadhu. Did I use any such words in my articles? Tilak further said, I have criticized the action of the British officials, not the British government. Self-rule is Swaraj, that is, involvement of the Indians in administration. In a case reported in ILR 34 Calcutta, it has been held that this demand is legal. There are anomalies in the government machinery, and pointing them out does not amount to sedition. A few bombs and explosives cannot overthrow a government in power, but at least the government must analyze the causes for the dissent amongst the masses. That is my only intention, and that is what I said. On the evidentiary value of the postcard, Tilak explained that there were only names of the two books which he wanted to read, as he was to write an article on bombs and explosives, since the government had recently passed the Explosives Act. As regards Section 153A, Lokmanya Tilak further argued that the section relates to the classes or religious groups. The dispute he was referring to was between the government and Indian National Congress. On 22nd July 1908, after arguing for 21 hours and 10 minutes, spread over 5 days, citing various judicial pronouncements and rulings of courts in India and England, Lokmanya Tilak concluded his arguments by pleading before the jury, which I quote. The freedom of expression that is available to newspapers in England be extended to us in India, and we must get it. Those amongst the honorable jury who are Englishmen are aware that they have this right, and this right they have obtained after fierce struggle. And I am sure they must be proud of the same. I plead that the same liberty be extended to us in India, and Englishmen should support us. I am not asking freedom of expression and speech for myself, but for my country. Unquote. After Lokmanya Tilak concluded his arguments and speech, Advocate General rose and criticized Tilak for arguing for 5 days and wasting time of the Honorable High Court. His caustic speech lasted for a few hours. In the concluding session, Honorable Justice Dawar pleaded to the jury not to be overawed or overwhelmed by the political stature of the accused. Justice Dawar concluded his address the same day by 8 p.m. Jury retired to the jury chamber and returned after 1 hour and 10 minutes at 9:20 p.m. with a divided verdict. 7 Englishmen held Tilak guilty and 2 Parsi gentlemen holding Tilak not guilty on any of the charges. While delivering the judgment, Justice Dawar said, and I quote, "To sentence you is my duty, but I am extremely sad to pronounce the sentence. You are extremely intelligent and powerful. You have great influence on Indian citizenry. Considering your age, award you 6 years of rigorous imprisonment. The sentence was delivered at 10:30 p.m. and Tilak was hastily escorted from the back door to prevent any mishap and taken by car to VT station, transported to Ahmedabad by special train overnight. The British government was so apprehensive of the possible violent reaction of the masses. The next day, Bombay was in flames. There were riots lasting 5 days, and 75 persons died of bullet injuries. When Lokmanya Tilak died on 1st August 1920 at Bombay, the largest ever congregation assembled at Chowpatty Sea Face, defying heavy rains, to bid a tearful adieu to one of the greatest sons of India. Lokmanya Tilak's statement on hearing the verdict is enshrined in the annals of history and is inscribed on a marble plaque in the Bombay High Court outside the courtroom where the trial was held. And I quote, "All that I wish to say is that, in spite of the verdict of jury, I still maintain that I am innocent. There are higher powers that rule the destinies of men and nations, and I think it may be the will of Providence that the cause I represent may be benefited more by my suffering than by my pen or tongue." Unquote.